Welcome back to the channel and buckle up, because what you're about to witness is not a routine courtroom exchange. This hearing explodes with tension, professional accusations, emotional frustration, and a judge who clearly feels that attorneys have crossed lines that never should have been crossed. Today's video isn't just about legal disagreements, it's about reputation, gender dynamics, courtroom culture, and what happens when private hostility becomes part of the public record. Throughout the script, you'll see moments where the judge becomes visibly shocked, the prosecutor becomes personally defensive, and the defense doubles down on statements the court finds inappropriate. As you watch this unfold, ask yourself, are these attorneys fighting about the law or fighting about each other? And by the end, decide for yourself whether the judge handled this professionally or whether the attorneys pushed him too far.
Her arraignment was on the 17th and the test was the 18th. So her assertion is that it was from prior to given the bond conditions. Regarding her use of cocaine, however, she has seen a doctor at the University of Michigan where she is beginning the process to enroll in treatment there. She has an appointment tomorrow at 2:30. And they are, the letter that she provided me that's dated today says that they've spoken with the addiction treatment team and are working to place her into intensive treatment and detox services. And tomorrow will be the follow-up appointment. Regarding the THC, she does have a medical marijuana card and did provide that to community corrections. And
what about her diluted sample? Go ahead.
This moment is incredibly important. When the judge pauses and speaks this carefully, you can feel the weight of what's been written behind the scenes. Judges don't intervene like this unless they believe someone has made an accusation that could damage a lawyer's career long-term. His warning, "You better be ready to roll with it," is a stern reminder that accusations of dishonesty, misconduct, or unethical behavior are no joke. In the legal world, your reputation is your currency. One accusation, even if false, can follow an attorney for years. And here, the judge is essentially saying, if you wrote this, you better be able to defend it, point by point. This isn't just procedural, it's personal, professional, and reputational. And already, the tension is unmistakable.
Or anything like that. She said she wouldn't even know how to. So given all that, Your Honor, my request is to keep her out of custody, let her go to this appointment at the University of Michigan, see if they can get her into treatment and detox. She is employed. She has 2 jobs and a young child. She works at the University of Michigan and at Five Guys. How old's your son?
He's not young. He's 15, but 15. I still care for him every day. Drive him back and forth to school, cook him dinner.
That's this individual with...
Here, the prosecutor isn't just complaining. She is documenting a pattern. She doesn't limit herself to the one filing. She brings up emails, comments, dismissive behavior, and a tone she feels is specifically targeted at her. This is where emotion meets professionalism. She feels attacked, belittled, and treated differently than her male colleagues. And remember, everything she says right now becomes part of the record. Future judges may read this. Attorneys who look her up will see it. What's powerful is that she's not shouting. She's calm, measured, but clearly hurt. And sometimes, calm frustration is more impactful than anger. Ask yourself, is she exposing real misconduct, or is this tension simply the result of 2 clashing personalities? The courtroom is getting heavier by the minute.
I remember I called and asked, is it okay if I can smoke? And they were like, we don't know. Then I found out yes. So I drank some bottles of water before the test, but I didn't do any hard drugs or anything. And I just really want to stay out so I can keep my jobs and stuff. And I can, because if I lose the job, then I won't be able to go to the treatment because I won't have the insurance.
Yeah, it's a horrible circle you placed yourself in.
Yes, it's all my fault.
Oh, it absolutely is all your fault.
I have a problem and I'm willing to try to get it fixed now.
Is that before or after you kill somebody with a car?
This is a bombshell. When she says, he would not do this if I weren't a woman, she turns a legal disagreement into a statement about systemic inequality. Gender bias in the courtroom is a very real issue. Many female attorneys report being interrupted more, challenged more aggressively, or spoken down to in ways male attorneys rarely experience. But saying it in open court carries risks. It can intensify conflict, trigger defensiveness, or even shift the judge's perspective entirely. Here, She's not just arguing the law anymore. She's arguing that the way she's being treated is fundamentally unfair. That changes the tone of the entire hearing. This is no longer just a legal dispute. It's a cultural one. And everyone in the room feels the shift immediately.
To prioritize that stuff ahead of him, and with the good stuff I finally do have going in my life, when I start doing good, I just want to be on a straight and narrow and get clean and stay out. I don't want to have to start from scratch. No, my mercy is in your hands.
Here's the thing I don't get. The test results from June 30th show in our system.
This request is strategic brilliance. Instead of debating personalities or demanding an apology, which could make her look emotional, she focuses on procedure. Remove paragraph 5 from the public record. This is about long-term protection. Public filings follow attorneys for decades. If the paragraph includes allegations that she lied, withheld evidence, or misled the court, even if untrue, it could damage her for years. By asking for it to be removed, she reframes the issue. This is not personal. This is about the integrity of the public file. Judges take the public record very seriously, so this request hits differently. And now the judge has to decide whether the defense crossed the line.
Now I'm going through all this stuff.
Yeah, you want to get here. You're an addict. You're going to get here and try to tell me anything and everything in the world to try to keep yourself out of trouble and keep from being accountable. That's what you're doing.
I just want to keep the positive things going in my life. I'm willing to admit my wrongs.
Anything else?
Well, Your Honor,
This is one of
I'd
the
ask
strongest rebukes a judge can give. I expected better from you. For an attorney, hearing this in open court is devastating. Judges rarely express personal disappointment, they stick to the law. But here, the judge signals that the filing wasn't just legally questionable, it was unprofessional. And remember, judges don't say things like this lightly. It means he believes the attorney crossed a line so clear, so well established, that he has to correct it publicly to protect the integrity of the process. This single sentence could follow the defense attorney for years. This is no longer a legal debate.
30 days
it's a
from
warning.
the time of her arraignment for her to have this appointment.
I work 2 jobs. I just don't want to lose everything.
And Your Honor, we have been in communication. We talked about this. She's willing to do treatment. I think she's admitted to the court that it would be helpful for her. I agree. On a lot of these cases, it's helpful, right? I guess I'd ask the court to take that into consideration today.
The defense attorney realizes he's in hot water and quickly shifts tactics. Instead of addressing the judge's point directly, he pivots and blames the prosecutor for misinformation, miscommunication, and confusion about the hearing. This is a classic defense maneuver: redirect, reframe, remove, blame. But here's the problem. The judge has already expressed disappointment. Once a judge thinks you crossed a line, arguing aggressively can backfire. You can almost feel the defense attorney scrambling to regain control while the judge remains unmoved. This is the kind of moment where the courtroom feels less like a legal forum and more like a heated workplace meeting gone wrong. The tension is thick and it's about to get thicker.
So between the end of June, so let's just say the beginning of July, coming up into September, she's still using.
Yeah.
And then when all of that kind of catches up with her, now I'm going to get myself enrolled in treatment, or I'm going to get myself enrolled in this. But even from the point of the time that she first saw me on the 17th of September till now, she hasn't done anything. Really.
Now we hit the core legal battle, the Rape Shield Statute. This isn't just a minor rule. It's one of the most important protections in sexual assault cases. It prevents irrelevant, invasive questions about a victim's sexual history unless strict procedures are followed. The prosecutor is adamant. The rule applies at the preliminary exam, period, the defense argues. Not the full mechanism, not the motions, not the offers of proof. But the judge sides with long-standing courtroom practice and victim protection. This isn't just a disagreement over interpretation, it's a clash between two philosophies. Should the system prioritize early-stage victim protection or early-stage defense strategy? And their tones show just how deeply each side believes. Their answer is correct.
I just want to do better.
If I am able to communicate with the doctor and coordinate some kind of plan moving forward, can I submit that to the court for your consideration?
Certainly you may, but you know, you can have a plan, but then she's gonna need to do it. Because I'm gonna tell you right now, she's coming before me, she's telling me everything that she's telling me, but she's lying to me like she's been lying to everybody in her family and everybody around her for I don't know how long, but certainly over the last year. Well, young lady, game's up.
And that brings us to the judge's final moments, finally ready to rule after one of the most dramatic, personal, and emotionally charged hearings we've seen. This case wasn't just about evidence, it wasn't just about statutes. It became a battle over reputation, respect, gender dynamics, and professional boundaries. The prosecutor defended her integrity and called out behavior she believed was dismissive and gender-based. The defense attorney pushed back aggressively, insisting his statements were fair, his filing professional, and his interpretation of the law correct. The judge found himself stuck in the middle, not just ruling on law, but restoring order, correcting misconduct, and reminding both sides what professionalism is supposed to look like. And now, finally, he rules. If you're enjoying these deep courtroom breakdowns, make sure you like, subscribe, and share, because our next video is only getting more intense. You won't want to miss it.